Ladies and gentlemen, I think we've really been informed as to the what, the how, the why regarding dealing with data and how to deal with things to improve the systems. Perhaps there's some questions to some of the speakers. If I can perhaps start with Aziz. Do we really need massive data to create a solid case? If we look at your system in Jordan in particular, where you started off with 10 lawyers, etc.
You can use ours. Hello.
It's very important to notice that such evaluations must not always be massive. It's not about the large amount of data, it's about the representation of the data. But proper documentation, so that you cannot take, for example, 100 cases and say they are representative of the criminal justice. It's how you present the data to ensure that you will always have credibility. But it's getting insight into the system. And of course, we don't always have to rely on quantitative data. Qualitative is, in many cases, very insightful. In fact, from my experience, every time we have held focus groups to identify the key issues, and then we conducted quantitative analysis in most cases, we would come up with the answer that we already had heard them from the people who are practitioners on the ground.
Thank you. If I can perhaps then turn to our last speaker, Marina. You indicated and you started to deal with the cost-benefit aspects. How do we, in a certain extent, balance cost and credibility in terms of the data that we get, etc.? One hand, cost aspects and the credibility of those in terms of those aspects.
The cost of collecting data,
Yeah.
is this what you're interested in?
Is that one working? Yeah. The cost of collecting the data versus the credibility of it in terms of what you gather.
Yes. So that's partially that's why I talked about two different models. So in the case of Malawi, of course, it cost much less because there was only one person involved who was doing everything, and he wasn't charging, a head and a half for his services. So it depends how many people you want to be involved in the evaluation. Also, because our partner organizations were interested in that, so PASI in Malawi, they were helping a lot. But also they used a lot of data that was kept by the ministries of justice, or the official data kept by various ministries that is relevant to that. So the virtual cost of that is zero. And they were cross-comparing, let's say, to official data versus what the pilots have done. So I think that's one of the ways. And I also wanted to add to the first question, about data and how much of data you need. So in case of Malawi, for instance, the evaluator found out that a lot of data simply wasn't collected, wasn't available, and there was no way he was going to find it in 3 months. So he found that the power of storytelling, as he tells it. So he went and interviewed, and that's why he focused on interviews with detainees and criminal justice actors to get inside the system, as we said, and to pinpoint what are the issues in the system. So that's time consuming. I think that's mostly time consuming and not as much cost, concerning.
John, you've indicated various things and 4 sort of ways to deal with various aspects, from resources right through to the various ways in which you evaluate the stuff. If you have all these results, how do you convince officials to implement recommendations?
Excellent question. Some of it depends on who's doing the evaluation and why you're doing the evaluation. So we need to remember that sometimes you're doing the evaluation only for yourselves, in which case we're not trying to convince anyone other than you of what's going on in your system and how it is you want to change it. If, though, this is about more systemic change, then it seems to me that we are talking about you having to partner with other individuals and with other groups. Now, in the last 2 presentations, this seemed to be evaluations by NGOs with external money, which means that there's an immediate partner right there that can help put leverage. When you don't have that, though, you may be able to find allies, either political allies within your own country or from the private bar. And I will give you an example in one state in the United States. So I don't know if any of you have ever heard of the state of Missouri, but the state of Missouri has a public defense system that has a caseload that is just ridiculously high. So high that the allegation was made that it was unconstitutionally high. An evaluation was done by the state public defender, and the state public defender was able then to file suit along with the private bar in the state court, and the Missouri Supreme Court found that it was unconstitutional to have caseloads that high. So that's an opportunity where you can do litigation with the private bar to make change there. But generally, if we are talking about larger systemic change, we are talking about that nasty word politics, which means that you need to be thinking about something other than simply law as the solution.
Thank you very much. Nicole, if I can turn perhaps to you. You dealt with performance measurements and those type of indicators, etc. If evaluation relies in part on the feedback of the lawyers giving it, how does one guard against self-interest on the one hand? And secondly, when you deal with these performance evaluations and the performance measurements, how can officers actually ensure that lawyers achieve the goals developed during those performance assessments?
Right. In terms of self-interest, so the feedback is coming from supervisors and mentors. And so they're sitting down with lawyers and they're essentially confronting them with their notes that have been collected over time in terms of monitoring that lawyer. And so there's not necessarily self-interest there. And in terms of ensuring that lawyers are actually achieving goals, when you create performance plans, and that's why at the very end I try to fit it in, you want to sit down with the lawyers and you're actually working as a team. So it's the lawyer and the supervisor working together to create performance plans that the lawyer actually works on with the supervisor and creates the different objectives and goals with the supervisor. And you want to work as a supervisor to follow up. For instance, a year ago, one of our lawyers was struggling with cross-examinations. He couldn't seem to execute them properly. And so that was his goal, is to become better at executing cross-examinations. And so to follow up with that, we did intensive court observation of that lawyer. When he would come back from court, we did direct feedback on his cross-examinations. And we also took every opportunity to move that lawyer in the office in front of other lawyers in order for him to get feedback directly from his peers. And so he was able to improve that. And so it's a very practical strategy as to how to actually make sure that these performance plans are implemented.
Perhaps one question for all of you. How does one, in view of the fact that there's limited resources, etc., build partnerships with other role players to help collect and evaluate these things? Can we start with you?
That's actually something that the ILF has done recently. We built partnerships with the UNDP recently on a juvenile justice survey to really do some research on as to what the reality is of juvenile justice, juveniles in the justice system. We also work with DCI, which is another civil society organization in the West Bank. They collect massive data on juveniles. And so we wouldn't spend all of our resources on recollecting that data when we can make connections with other actors in the community who are already doing this work. And that's also important just for building relationships as we're all trying to move toward ideally the same goal, which is increasing access to justice.
Thank you. Marina?
As we mentioned in the morning session, it's important to have the government, or at least the relevant branch of the government, on board from the very beginning. And that was the case both in Malawi and Sierra Leone. And of course, you wouldn't be able to plant paralegals in prison, police stations, and courts without Ministry of Justice at least being on board. So I think the close partnership, the same as Nicole mentioned, and kind of being with respective actors at every stage of the pilot project, and then probably educating them on the developments in their legal framework, or even as we did after the UN guidelines and principles were passed, they create a roundtable, where they talk about that and like, hey, we should probably bring up our standards to that, that's how we can do that. And also I think, for instance, in case of Sierra Leone, having control sites and treatment sites was also interesting and intriguing to the government itself, because you could show it very easily and clearly the difference. This is, if you do it this way, this is what you have in this region. If you do it in the control site way, this is what you have, and this is how we can help you. And we already have a model that's working and easy to be installed. All we need is your will and support in that. So.
Well, I think first of all, need to emphasize that this shouldn't be as scary as it may seem. You do not need to start with an evaluation program that looks as good as the last two presentations that we saw. Simply beginning to have a culture in your own offices of evaluation and assessment is a first step. So I come at this a little bit differently. I look at the assessment as being started by the legal services provider. Then in terms of how do you do it if you don't have the resources, you reach out to the kinds of NGOs that we've heard on the panel today. But I would also encourage you to think about reaching out to area universities that have, I would like to think, smart people on staff, and oftentimes have, at least in the United States, very cheap people available, i.e. students, who are able to participate in some of the work. So I think there are ways of doing this, and I do not accept the notion that it is too expensive or too time-consuming to do this. I think rather it takes creativity and a willingness.
Well, first of all, it's you must invest in time to design a good assessment, because what a common mistake is to collect too much data. That usually means it will be too expensive to collect, and it will be too time-consuming to analyze. Another thing is that we must create internal systems for data collection within our own systems that are easily implemented, not too time-consuming, and not too difficult to analyze later on. And my final comment would be to tap into not just universities, which is excellent, but for example, in many of the third world countries, tap into existing institutions. For example, Department of Statistics, who are already doing surveys. You may pay a little bit and add a question or two to an existing, to an already designed survey, and this is what we plan to do.
Thank you. Let's open it to the floor. Let's start on that side. Any questions to the panel? Not? Middle? There's one gentleman there.
My name is Ade Omofade. I'm a Justice Sector Reform Coordinator with UNODC in Nigeria. My question is directed to Nicole. Nicole, I found your presentation very interesting and very informative. The challenges that you raised regarding logistics, lack of electricity, infrastructure, and so on and so forth, when it comes to case management recording, are ones that resonate with many of us. The question, therefore, is did you also find challenges regarding actual recording of the information in a computerized fashion? That's the first one. The second is you referred to the alternative of manually recording information, which is a good one. But did you also encounter any challenges as regards storage of manual recorded information? And if so, how did you overcome it? And I'm sorry, the third phase to the question is what steps have you taken regarding sustainability of any systems that you've managed to put in place in these developing systems? Can you share any thoughts with us?
Thank you. Let's immediately answer that.
Thank you so much for your questions. And I have to say yes, yes, yes to all of them, but I'll explain. The first one is finding challenges to recording actual information. I think one of the major challenges that we face is one, when we move from the basic, well, even with the basic Excel spreadsheet, is making sure that all of the information is actually recorded. And so you have lawyers who are very busy, you have very limited support staff, and so, you know, we found often that all of the information wasn't actually making it to the system, which really affected, kind of in those charts, affected the reliability of the information that we were providing. And so what we did, and this was kind of to my last slide, is it's about training. And it's about monitoring, and it's about truly spot checking and making sure that the system and the file are actually accurate. And so that was one of the major challenges. And then also finding a particular program that works for the office. And so what may work in Nepal may not necessarily work in Afghanistan, again, which may not necessarily work in the West Bank. And so it's identifying a system, an electronic system that's actually going to work for your office in the capacity of your office. So that's one really quickly.
Storage?
Right, storage. I'm going to storage. Storage, yes, we have issues of storage. We represent, Afghanistan represents 28,000 cases. So of course we have issues of storage, but we do the best we can at, finding locations for our offices that have facilities to store. There are laws in each country as to how long you have to keep files for. And if you do have a system that is working properly, then you can, files that are 15, 20 years old, 15 years old, 10 years old, 8 years old, you want to consider, either making a copy and maybe getting rid of the file. And so you have to be kind of innovative with how you're going to store your information. But we do have that problem, particularly in Nepal, where the office is really, really small. And you have to do what you have to do. Really quickly, on alternatives to the alternative to manual recording manual information, and again, the issue is making sure that the information is there. And so it's training lawyers to fill out their case files properly. It's training the data input officer to actually input the data. And in terms of sustainability, which is your last point, in each of our offices, we've hired a data person, right? Someone who is dedicated specifically to ensuring that the case management systems are operating effectively, and that the information that we're pulling from them is reliable. And that one person is then responsible for interacting with all the lawyers. And so it's sustainable because it's actually one person who's trained how to do it, who interacts with the lawyers, and who ensures that the system is accurate and reliable.
Thank you. Middle group, any questions here? Anna?
Thank you. I'm Werner Kroll, UNIC. First of all, I would like to ask a question. I saw the ILF presentation. There was a reference to an ILF Pro file system. Is that something you would be willing to share with nations? Because it looks as though it works beautifully. And then secondly, directing my question at Professor Gold, one thing that I hear from the presentations is the old business line that if you're not measuring, you're not managing. Hasn't the time arrived to view legal aid system as a business, albeit not the for-profit method, but also running along the lines of business processes, impact assessments, and very importantly, sustainability?
You want to quickly?
Really quickly. The FileMaker Pro system is actually not our system, so I don't want to put it out there that that's our system. It's a system that we pay for and that we're using. It's actually very effective, and so it's an intuitive system. So any intuitive system that's easy to use, easy for your lawyers to use, is something that you're going to want to look into, and that can capture, accurate information, a fair amount of information, where you can present or generate reports that are going to help you advocate for your program, is what you want to look for.
Werner, she's saying take it offline, building partnerships. John?
I'm tempted to simply answer yes and be quiet, but I'm a professor, so I'm constitutionally unable to answer any questions simply. I think that absolutely it is important to have best practices in place where we are assessing ourselves. By us, I mean legal services providers, against what we claim to be accomplishing. One of the objections I oftentimes get when I give this presentation is, oh, you're from the United States. You're giving the US perspective here where there are lots of resources and everyone's able to do this all the time. Now, I think my American colleagues in the audience would tell you that they don't have the resources to do this on a regular basis, and I see by their smiles that they would agree with me. But let me give you an example from here in South Africa, from a process that I was involved in 1993, where an organization was starting a training program to put paralegals in rural communities in KwaZulu-Natal. Even then, they came up with a system to have paper documents in the rural areas for the paralegals to record what they were doing all day and what happened in the cases. And these were simply held at the rural offices, and once a month someone would come up, pick them up, bring them to the main office in Durban, and they would get recorded and they'd be analyzed. So I don't think that this is simply a more wealthy country, more developed country perspective that I'm giving here. I think this is something that can be done and has been done successfully in a number of places.
Right, let's shift over right to the other end. Start there with some questions there. Gentleman there.
Thank you very much. Good morning to everybody. I will speak in Arabic, please. I will speak in Arabic. Okay, ready?
Can you first identify who should answer that and not preparing?
اسمي فهد المحمدي، خبير قانوني بمكتب سعادة وزير العدل بدولة قطر. في البداية طبعا موضوع تقديم المساعدة القانونية في ظل نظم العدالة الجنائية من أهم الموضوعات الآن المدرجة على الأجندة الدولية والإقليمية والمحلية في العديد من دول العالم. ولا شك أن حق تقديم المساعدة القانونية هو من الحقوق الأصيلة المرتبطة ارتباط وثيق وأصيل بحق الإنسان، وهو منصب عليه المواثيق الدولية وبينها الإعلان العالمي لحقوق الإنسان وأيضا العهد الدولي للحقوق المدنية والسياسية كما تعلمون. ولكن أنا وجهة نظري المتواضعة أرى بأن مرحلة تقديم المساعدة القانونية تسبقها مرحلة لم يتم التطرق لها أو من خلال كلمة طبعا من خلال أجندة المعروضة على جدول الأعمال اليوم وبالأمس. بالأمس تحدث السيد كليفلد مسيستا لو نطقت اسمه صحيح عن هناك بعض الانتهاكات والمعوقات في مراكز الشرطة على سبيل المثال في العديد من الدول. وأيضا الأخت هديل اليوم تحدثت الأستاذة هديل عن أيضا امتداد لهذه الانتهاكات في بعض مراكز الشرطة وما إلى ذلك. ألا تعتقدين، أنا سؤالي موجه للأستاذة هديل ولمن يرقب من السيدات والسادة المتحدثين، ألا تعتقدين أن هناك مرحلة هي مرحلة تقديم الوعي والتثقيف القانوني لأفراد المجتمع من ناحية، وأيضا من ناحية أخرى لرجال الشرطة ولرجال القضاء القائمين على أو قائمين في أثناء حجز المشتبه. هناك قاعدة قانونية مهمة الجميع يعلمها أن المتهم بريء حتى تثبت إدانته. فبالتالي لو تم تثقيف أفراد المجتمع بحقوقهم القانونية بموجب القوانين والمواثيق، وأيضا تم تقديم دورات تخصصية في المعاهد القضائية والقانونية لرجال القضاء ورجال النيابة العامة، ألا تعتقدين أستاذة هديل أنه راح يتم الإسهام في على الأقل التقليل من انتهاكات حقوق الإنسان في أثناء مرحلة الاحتجاز؟ هناك العديد من المبادئ التوجيهية التي نصت عليها وذكرتها الأمم المتحدة سواء لرجال الشرطة أو لرجال القضاء، ولكن من الناحية العملية نحن نقدم المشاكل ونذكر معوقات، ولكن ما هي الحلول؟ هناك يجب أن نقدم حلول نموذجية أو تخصصية في هذا المجال. فألا تعتقدين أن موضوع التثقيف القانوني لأفراد المجتمع ورجال القانون والقضاء ورجال النيابة العامة هو سيحد نوعا ما من هذه المشكلة؟ وشكرا.
Thank you. I think we've noted that question. I just want to indicate that in some of the breakaway sessions, it was specifically dealt with that there is a great need for awareness raising.
راح أجاوب بالعربي. صحيح طبعا بلا شك التثقيف مهم، تدريب القضاة مهم، تدريب رجال الشرطة مهم. عفوا. راح أعيد إذا أنا بوافقك إنه كل اللي تفضلت فيه هو مهم، لكن إحنا لازم ننظر إلى العدالة الجزائية على إنها سلسلة. هي سلسلة تتكون من عدة حلقات. لا يمكن أنه ننتظر حتى تصلح كل الحلقات ومن ثم نقول أنه سنحمي حق الفرد بالمساعدة القانونية أو حق الفرد في حق الدفاع الشرعي، لأنه بالنهاية يجب أن يتم بالتزامن. نعم، أنا بأكد لك التوعية لحالها أو تدريب الشرطة لحالها أو تدريب القضاء لن يحمي حق الفرد من الانتهاك ومن التعذيب أو حتى من سوء الفهم. هو لن يجعله، لن يحل مشكلة شخص يعترف بتهمة مثلا شروع بالقتل وهو يعتقد أنه يعترف بالإيذاء. فبالتالي وجود محامي هو بحد ذاته هو ضمانة قد يؤدي إلى التوعية والتثقيف ويؤدي إلى تطوير ممارسات الشرطة والرقابة حتى على ممارسات القضاء.
Thank you. Can we, any other questions on that side? Can we turn to this middle row? Lady first.
Hello, my name is Anat Horowitz. I'm from the Israeli Public Defender's Office. And my question was, I think it's directed primarily to Professor Gold, but perhaps to all the panel. I think you made a very good case for the advantages and the different uses one can make out of collecting data and analyzing it. I heard nothing about the dangers of obsessing with numbers, and especially in using numbers to evaluate performance. And I think there's two major difficulties or dangers that are involved in this, and I wanted to hear your perspective on this. The first one is, of course, the dwarfing of soft variables. You know, not everything you can count, and especially in our profession, many of the things that you can't count are extremely important. And you know, when we think about a client-centered approach, then an issue such as outcomes, emotions, Nicole was mentioning the importance of speedy trial, but we say we know that there's a contradiction between speedy trial and perhaps fighting for your innocence in court. So if we're only interested, we're counting speedy trial, how long does the case last in many cases, then perhaps the lawyer who's involved is plea bargaining all the time and not effectively trying to defend his client's innocence when they claim so. So when we count things, we miss out on what our occupation is all about, is giving voice to individual clients who have different needs and desires, and that does not come out often in numbers. And then we're distorting our sense of what quality service is. The second danger I see is the impact of having these kind of evaluations on performance later on. I mean, lawyers know that they're evaluated by outcome, that they're evaluated by the number of motions they file, by various quantifiable criteria. It necessarily impacts their performance and makes them start performing in a way that will make them impressive on paper, make their numbers look good, but harm the quality of the services they render. So these are two major dangers. I'm sure there are others, but as nothing was said about this issue, I was wondering for your remarks.
Thank you. John?
Could you say that? I'm sorry, where did you say you were from again?
I'm from Israel. I'm from the Public Defender's Office in Israel.
Okay. So I think you make very good points. One of the things, and I need to remember that as a researcher, I use a term differently than the lay person does. So when I mention data, I'm not talking about numbers alone. If I'm talking about numbers alone, I'm talking about quantitative data. Data encompasses both quantitative data and qualitative data. You were using the expression soft data, that would be qualitative data. Any good evaluation is to taking account of qualitative data. In other words, what people are telling you rather than simply what you're reporting on numbers. And I thought the two presentations that were given, actually all three, show very good use of qualitative or soft data. Those are incredibly important. It's one thing to say that a case takes 120 days to conclude, and another to figure out what's the lawyer doing and what's the evaluation, what's the quality like. So it's important to interview lawyers. It's important to oftentimes have roundtables or focus groups. It's important also to talk to judges and others, if you can, to get people involved in this process. So I agree with you there. That's number one. Number two is the issue of how you guard against simply being evaluated on numbers alone. And that's why it's imperative that whether it's you as your office doing the evaluation or someone else that's doing the evaluation for you externally, that you have a role in the process. You need to be involved. You are either the ones giving them access to the data, doing the evaluation, or hopefully you are also involved in the interpretation of the findings so that this is used in a way that best improves quality. But I will finally disagree with you on one point. I actually think it is useful and imperative for lawyers to be careful about what they're doing, and an evaluation is a very useful way to help them understand. I've done a number of evaluations in the States where we are finding that lawyers in one part of the country are filing many, many fewer motions than in others. And that's an issue of concern. And I don't have a problem with attorneys having to answer for things like that, so long as you were saying at the beginning of your question, that numbers alone are not the only criterion that we are using for evaluation.
Thank you, John. Nicole?
Yes. Thank you, Annette, for your question. And that just goes to my point with regards to performance evaluations, specifically the performance evaluations that we do at the International Legal Foundation. It's not just about statistics. And so it's a conversation between the supervisor and the lawyer. And it highlights a couple of things. It's important to have supervisors who understand what it's like to try cases in court. So that when the lawyer says, I'm doing that, but I'm struggling with getting these issues across to the judge, or I'm struggling with writing this particular type of motion, the supervisor understands what the lawyer means and the lawyer's experience. But these performance evaluations are, they're made up of notes from supervisors, from mentors, case discussions. And so you encourage lawyers to sit and talk about a case, right? So you can see, what the lawyer's thinking is at this stage in their kind of development. And then statistics, right? Because like John was saying, it is important if you're dealing with intake that the lawyer is not going to the detention center. How many times the lawyer is going to the detention center. If you're dealing with pretrial issues, it is important whether or not the lawyer is filing necessary bail motions. It just is. But I agree with you. It's not the end-all be-all. It's just a part of the totality of the evaluation.
Sorry. Can I add to the other question in Arabic?
Yeah.
Briefly, if I understood the translation correctly. And perhaps it didn't come across clearly as I was going through fast my presentation, but in both pilots that I was talking about, the importance of legal rights and legal awareness was a key component, and I have to agree with Hadil. We had to launch it in parallel, basically. We didn't have the time to wait, let's test that, and then let's do that. So basically, both organizations focused on educating communities, and within communities, we mean communities, people, families who are outside of the prison system at the moment, the detainees themselves, and also the actors, police, judges, prosecutors, so they all know what are laws and regulations, and as a result, and that was part of the statistics that I mentioned, one of the reasons why bail went up, is like people found out, oh, I have a right to bail, and also, oh, I don't have to pay to apply for bail, because police was saying, well, if you want to be considered for bail, you have to pay. Also, people in the community found out what it is to be a surety in the context of the criminal justice system, and they were more willing to become sureties for somebody else, for a relative or whoever, who was in detention. So that's how the pretrial detention rate went down. People were not sitting in prison. Also, we understand that police and judges are very busy with their daily work. They don't have the time to keep up with all the legislative changes. So that's why court camps were important, where they were, they were told, so as of whatever date this law came into force, and now the limit to pretrial detention is 48 hours for that offense or suspicion and 10 days for that. So past that, you do not have a right to hold the person, either release him or you have to move on with the case. And that's why we could see almost immediately, the results of these educational services, targeting all on probably monthly or at most quarterly basis, to keep everybody up to date. What are your rights? What are your, responsibilities when it comes, like everybody's involved.
Thank you. All the presentations will be on a memory stick, so please go through it very carefully. Gentlemen, there at the back.
Thank you. This is Sunil Pokhrel from Nepal Bar Association. Thank you all panelists and presentation, particularly to Nicole Zeller, who presented very articulately about the situation of Nepal and how the evaluation and monetary system works to improve the system. My concern, my observation is with two presentations, which is more or less completely different from our perspective. The first was presented by Aziz of Jordanian perspective, and the second was presented by Marina about the Malawi. Like in the first presentation, Aziz presented that the cases, she presented the data, given the data, 76% cases goes for the detention, and when there is a final disposal of the case, only the out of 76, 36% are convicted. So my concern is that what is the problem with this the fluctuating data about the detention and the conviction? Like it is due to the early access to justice or non-representation, or it's because of the continuous evaluation and monitoring of the service delivered in your jurisdiction. Second, my question with Marina, like she brilliantly presented about the pilot work carried out in Malawi, and she said that in Malawi, during the pilot project, they are mentioning they are deploying the paralegals, and she has also given the data that due to the service of paralegals, many cases are dropped or detainees are released. So whether the paralegals are also providing the service of legal issues or only non-legal issues. So far as I understood from our presentation, they are dealing with the legal issues as well. If this is the situation, how you are dealing with the quality issues, and how you deal with the evaluation and the assessment of this quality issue during your pilot project. Thank you very much.
Thank you. Please, Aziz.
Can you please repeat your question? If I'm worried that I did not get it completely. Can you please? I'm sorry.
Like I'm giving you the comparative, like what Nicole presented in our jurisdiction, Nepal. She presented in Nepal, and then you presented like some facts and figures, like 76% cases go for detention, and you mentioned that the prosecutors use detention as an option, not as exemption. And then when there is a final verdict, then the cases out of 76%, conviction rate is 36%. So whether this is the question of this is a problem of early access or non-representation, or there is some problem or error in the system as well.
Thank you. We did analyze the reasons through interviews with judges and prosecutors. There is more than one issue. First of all, it was the law, because the law gave all authority to the prosecution to just detain people if they thought that was the case. And then there was the culture among prosecutors that they were more worried about people fleeing or not coming back for court for the trial They were more worried about them escaping the system rather than worrying about putting people who should not be detained in prison. In fact, now we are lobbying and we are advocating to amend the law so that every decision of detention, it should clearly state of why it was made, and it should be limited to 3 main reasons. One would be that there was a case, it was a high risk of flight, or they could tamper with the evidence, or they were a risk to the community. It's not, so like before the current law, simply all the prosecutor has to do, we will detain them for the best interest of the investigation. That is just not good enough. Of course, there was no pre-trial representation, but even when there were, actually our study showed that when you have a lawyer, you will be also detained. And that had to do with the fact that the role of the lawyer, according to our law, is very limited. They are not allowed to speak unless they are given permission by the prosecution.
Thank
So
you.
it's complicated.
So obviously, I think context changes between country and country, and I think there are factors that one needs to bear in mind in terms of it. Marie?
And before I answer my question, can you please clarify what in your question you meant by non-legal issues, so I make sure I answer correctly and not what I think you think?
During your presentation, you mentioned that the paralegals also work the bridge between the detainees and the families. So these are some non-legal issue about the families issues and these kind of things. So my question was, they are dealing with the legal issues, because you said that with their help some cases are dropped and some are released and this kind of thing. That's why they deal with...
I understand now.
Yes.
Thank you. Yes. So the answer to that would be both. Then they deal both with legal issues and non-legal issues. So legal issues would be dealing directly with police, detainees themselves, and any other relevant stakeholders, and then non-legal issues, because we found out, and also PASI and TMAP in Sierra Leone, they think it's important to work with communities, to gain community recognition and approval of their work. So that's why partially, contacting family members, that helps with the legal issues, to arrange for bail or surety, you have to contact somebody. Police doesn't have time to do that. That's what we found out, because, maybe they're understaffed, or often the issues of electricity, phone lines, everything like that, they don't have the capacity to do that. So paralegals basically volunteer to take on that duty and inform family members or community leaders, that such and such person, especially if they're arrested in a different province or territory. For the other question, quality assurance, probably, I didn't mention it, I'm pretty sure, but all paralegals are supervised by lawyers. So the models that we tested, they're paralegal heavy, and for instance, for 4 paralegals, there would be 1 lawyer who supervises their work. And also paralegals have the ability to go to a lawyer and hey, I don't know, I'm not sure if this is correct, so the lawyer is able to supervise. Basically, we promoted the model of paralegals, that there are certain tasks that paralegals can do that lawyers don't really have to be involved in. So for instance, in our models, lawyers come in either in really complicated cases or at the point of court hearings. So of course, paralegals do not have the right to represent at courts, so that's where a lawyer comes in and takes over the case. And also there is a lead paralegal, basically that would be the most experienced paralegals, maybe who work the longest or who is the most educated. So they also supervise on a regular basis. They go around the sites and visit paralegals, regular paralegals, and they monitor their work, and they assess and evaluate their work. And also we do regular training sessions for paralegals themselves, where they come together and they cross-compare their practices across the country, because they're spread out everywhere and practices are different. So they discuss their issues, and also the importance of training them, on developments in the legal aid system, all laws, so they can respectively pass on this information. So I think that would be the most primary quality assurance. I'm sure there are a few others, and I just don't want to take the time, and if you want, we can talk later about that.
Thank you very much. I think that basically brings us to a conclusion of this session. I know there's many other questions that you would like to pose. The speakers will be around here for the next couple of hours still, so please engage them. From my side, thank you very much to the audience for your participation, and a special word of thanks to the panel members who so clearly indicated why we need to deal with data analysis, why we need to gather these informations, and how to ensure that there's integrity in terms of these aspects. Can I ask that you all give him a hand of